Good morning. This is Tom O'Connor. We're here this morning to have a discussion about social media discovery, acquisition, the problems with all of the issues that surround social media in the e-discovery world. And I'm here with Bill Hamilton, who is a board member on a great new company that I've seen that's starting up called Social Evidence. The CEO is Andy Adkins, who many of you know from his days as the chair at the ABA Tech Show. But I'm sure more of you more recently know Bill from his work. Bill's worn a number of hats. Of course, many of you know him from Bryant University online educational efforts and his teaching at the University of Florida Levin College of Law, which I always have to remember to get correctly. Bill's also the director of iCare, the Center for Automated Information Retrieval at the School of Law. And one of their projects that you may have heard of is the e-discovery project. And Bill is also, his other hat is as a litigator, former partner and head of e-discovery at Quarles and Brady. And so he has a unique perspective as both a litigator and an educator in this field, and I want to get both of those perspectives. Good morning, Bill. Thanks for joining us.
It's a pleasure to be here, Tom.
So you're in the forefront of much of the development of this, as I said, from wearing both of your hats. I don't think it's any surprise for anybody to know that social media has exploded. I saw a stat yesterday that something like 89% of all Americans are using social media in one form or another. Facebook, of course, is a huge issue, but Snapchat, Instagram, we could go on and on and on and on with all the ways that people are connecting. And it's evidence, or it's potentially evidence in a matter. If an individual is involved in some sort of a legal dispute, there may be relevant information out there in social media land. Have you seen that rise in demand for dealing with social media?
Yes. One of the ways to look at it, Tom, I think, is to talk about just phases of electronic discovery development. You know, we had kind of the first wave of electronic discovery that went back maybe 10 years ago, and that was principally composed of what we'll call office documents. You know, Word, email,
Right.
PowerPoint, those kinds of traditional documents we saw in the business context more than anything. Now we're at the second deluge, if you will, and that's the deluge of social media and cloud information that is really more intense, actually, than we saw with email and office documents. You know, we remember the old stories about emails and smoking gun emails. Well, that's nothing compared to the quality of the evidence that we can find in social media now related to a wide variety of activities. And it's really beginning to penetrate business as well, not just merely, you know, personal issues and personal kinds of cases such as personal injury or family law, but it's invading intellectual property cases, it's invading contract cases, antitrust cases. Everyone is communicating now in various social media channels, and businesses are doing it because they have to for competitive reasons, you know, not because they have kind of been dragged to a kicking and screaming, but they want to take advantage of this wonderful opportunity it presents, but at the same time, it presents challenges and dangers as well.
So it's interesting you should say that. I mentioned before we started recording here that I taught a CLE yesterday in Austin, Texas, to a room full of people from corporate GC offices. And that was one of their real concerns, that they have some sort of a social media presence or presences. And how do they control it? In the first instance, they aren't always aware of who runs the social media, whether it's a Facebook page, a blog, et cetera, or it may be multiple groups inside the corporation, depending on the size of the corporation. So just, if you will, from the info governance side, knowing what they have and who's in charge of it is a big problem, which of course makes collection a problem. And so I'm hoping that Social Evidence will will deal with that. It's a more robust tool than some of the others that are out there now. And I understand we'll be able to go out and grab information from multiple sources. Am I voicing that correctly?
Yes, indeed, Tom. That's the whole idea behind it, is to create a software that will be able to access and capture social media information in a format that's usable ultimately, as you were pointing out, to become evidence in cases. So we have a couple problems along the way. One, we have to preserve this information. And then we're also getting to the point, and this is a big change that's taken place, that social media locations used to be relatively modest in terms of their size. In other words, I could go through my own social media Facebook page a few years ago and maybe spend an hour flipping through the pages and kind of cover it all. So it wasn't a huge ordeal to go through it. Now what we're seeing are Facebook and social media pages that are thousands and thousands of pages, and you simply can't sit down and go through those manually one at a time, looking to see which ones are evidence and which ones are not, or which ones are relevant to a document request. You've got to have technology that we've developed and use in other contexts available to slice and dice and sort and analyze social media as well. And that's what social evidence does.
And so now I'll ask you to comment from, or put your litigator hat on. You mentioned something in terms of just searching and looking, but certainly in terms of authenticating and producing in in a deposition, in a motion, or even in trial, social media now is a real problem because of that print one screen at a time issue. That becomes extremely problematic, and so we're looking at a tool like social evidence that will be viewed as an authenticator, if you will, in that format. I see that as a real improvement.
Yes, what we've typically done in the past, going back 10 years, 5 years with social media, is, you're right, we took screenshots, maybe an Adobe capture, maybe a capture with Snapchat, but essentially you're dealing with static images. That creates all kinds of admissibility problems because it resembles getting a photograph into evidence in the old days. So what you have to do is you have to say, well, when was a photograph taken? Who took it? Under what circumstances? Was it altered or changed? So it involves having a series of witnesses. And of course, those witnesses can be challenged. How was it maintained? How was it kept? We all know that electronically stored information is fragile in the sense that it's really easily alterable.
Right.
I like to tell the story of when I had a picture taken with a local celebrity, sports celebrity once, and I sent it to my son so he could see how great his dad was hanging out with luminaries in town, only to come home and find him upstairs with his buddies and showing his buddies this picture. I thought it was a great picture of me, but he had photoshopped himself into it with the celebrity. I wasn't there anymore. So we all know you can change electronically stored information relatively easily.
Right.
So what social evidence will do is it will capture appropriate metadata, it will do hash values, it will apply an appropriate signature to the document, so we can demonstrate through a chain of custody that yes, this particular artifact was captured at this time from this location and it hasn't been changed. And that will facilitate the whole admissibility and authenticity problem.
Right. So, and I don't mean to put you on the spot because I know the product is still under development, but you mentioned Snapchat. There is an increasing trend, and I actually read an article just this morning about Twitter losing stock value and market share to more video-oriented sites, and Snapchat was one of the ones that they mentioned. Is that something that social evidence will be able to deal with as well? And everything from YouTube to short 1-minute video clips?
Yeah, that's on the development phase right now. And I think you're absolutely right, Tom. We've got to look to the future. Social evidence is being built not for right now. In the traditional hockey metaphor, we're building the product for what the puck is going to be, a year, 6 months from now. I think even Facebook just came out. I think Zuckerberg said that they anticipate, or someone from Facebook said they anticipate that the primary electronically stored media on Facebook will be video in just a few years from now. So that creates very interesting challenges as to how, one, you collect it, how do you search it, how do you analyze it, what metadata is associated with it. We're deep in the trenches in that problem with social evidence.
Yeah, I'm seeing those same sort of reports that, of course, as bandwidth gets better, faster, cheaper, and technology in general gets cheaper, that video is going to be the new text. And as always with technology, that's probably closer than we are ready for. Um, and
Right.
I think it's going to present a lot of problems.
And just think about the challenges associated with evaluating that. We just don't have the time and the energy, and clients can't pay to sit and have someone staring at a screen watching mostly inane activity for 20, 30 minutes, to find maybe a section of it that happens to be relevant. That's just not, to use a contemporary expression, that's just not proportional, under, Rule 26, A
Right,
anymore.
right. Excellent. So let me flip the switch here and ask you to put on your educator hat. Um,
Okay.
as you know, you've been in the forefront of this, and we had discussions many years ago with our old friend Browning Marian and George Sosha, uh, who started the EDRM and is now joined us in the consulting world, has been in the forefront of this. How do we get this out in front of the students? How do we get this out in front of the practicing attorneys? And how do you, as an educator, keep on top of all of that? These developments seem to be almost breathtaking in speed.
Well, it is, and of course, that's one of the great things about my transition to full-time faculty at the University of Florida, is I can focus on this and keep track of it while not worrying about billing 40, 60, 80 hours a week. So that's a nice transition for me to stay on top of it. But how do we teach it? It depends upon where you are in your practice and what the demands are. Too much time, though, Tom, we've spent in the past with electronic discovery trying to scare people to death, saying you're going to get sanctioned if you don't do this right. And that wears thin after a while. I think really what attorneys are interested in doing, and law students want to do, they want to be successful. So this is evidence, and I think the effort is to persuade our attorneys and our attorneys to be law students that this is the kind of evidence you want to get a hold of. This is the kind of evidence that's going to make your case. This is the kind of evidence that's going to allow you to represent your client in the best possible way and ultimately allow you to be successful as an attorney. If you're not doing that, you're going to be behind the eight ball, doing your client a disservice. So once we understand that we're dealing with evidence, and more evidence than we ever had, then we can start figuring out how do we get the right stuff, how do we get the important stuff, and how do we utilize it properly.
All right. So speaking of that, and speaking of being in the forefront, the state of Florida, of course, very recently, within the last 30 days, as I understand it, the Bar Association passed or recommended to, I guess in your state, the state Supreme Court signed off on a change to the CLE requirements so that there is now a requirement for 1 year of technical training in the MCLE requirements. Am I explaining that properly?
Well, yes, close, Tom. The details are that we have 3 additional CLE hours within a 3-year cycle, and 3 of those hours have to be technology related. And we have to think of technology in the broader sense. It's not just electronic discovery technology, but
Right.
what the bar wants all attorneys to understand is that we're dealing in an electronic ecosphere. So that's relevant for trial attorneys going to trial. It's relevant for office attorneys who are building documents. It's relevant for attorneys that are filing stuff at the courthouse. We can't escape the digital environment we're living in. And that's the message, I think, that the Bar and the Florida Supreme Court has sent out. That's so important that, frankly, we've been leading the charge in that in electronic discovery and at the University of Florida Levin College of Law.
Oh, yeah, absolutely. But I'm really excited by the fact that it's now a requirement. It's a professional requirement imposed by the Bar. I'm hoping, I don't know if you've heard anything about this, that other bar associations will start to stand up and take notice and act accordingly. We need to be doing something to prompt better technical awareness in attorneys. Yes, your school, certainly the Levin College of Law, has been at the forefront of that. Unfortunately, that list of schools who have been is woefully short. and oftentimes we have one program. Our friend Craig Ball teaches a class at the University of Texas Law School. I know the folks at Chicago Kent School of Law have some good programs, but we could probably tick off on one hand the law schools that are really taking this that seriously. So I'm hoping that Florida's lead in this will pick up some steam. And I guess we'll just have to wait and see. So anything else you would like to mention about social evidence that I have neglected to point out in terms of the importance of getting at social media? I will tell you, I'm excited about seeing the tool. I haven't seen a demo of it yet because it's too early, of course. But the descriptions of the developers and the folks like yourself who I know are involved with it give me great hope that it is a program I want to get my hands on.
Well, thanks a lot, Tom. And I hopefully we meet your expectations. I think we will. The key here is that most electronic discovery software in our product, social evidence will be that way, is becoming easier and easier for attorneys themselves to use. We're not living back in a DOS world where you're typing commands into a black screen and getting your computer work. We're dealing in a very fluid environment where most attorneys are going to be comfortable enough to use this software themselves, or at least they're paralegals. So the idea behind the software is to help us get to evidence that's important for the case easily, simply, in a way that's intuitively understandable by attorneys.
Great. Well, Bill, thanks so much for your time. I know you have a busy schedule. I appreciate you taking some time out to talk to us, and I look forward to seeing you. What have you got coming down the pike? What have you or the Levin College of Law got in the works? Anything coming up you want to mention?
Well, we have our distinguished speakers coming for the spring semester. There's going to be actually Maura Grossman and
Great.
Gordon Cormack are going to be coming to the University of Florida. We'll be having a confab with them about the upcoming advancements in artificial intelligence and predictive coding in TAR. That'll be happening on, I believe it's February 20th. And then we have our fifth annual conference on March 30th, online and in person. And that, of course, is the conference, we like to call it, for the other 99%. It's designed for the attorneys and paralegals and litigation support professionals who are out there in the field struggling with e-discovery problems that need a neutral, reliable source to show them practical solutions. So that's on March 30th.
Yeah, and I look forward to that, of course, every year, as does my colleague at Advanced Discovery, Kanan Himmelbaum, who's a former student of yours and active and still active, as I understand it, and helping out with things at the school. So I'm looking forward to that. March 30th, you say?
Yes.
Excellent. We'll put that on the calendar. Bill, thanks again for your time. Really appreciate it, and look forward to seeing you in person again.
Good talking to you, Tom. Thank you. Bye-bye.